Hi, I'm Cian O'Carroll, and back in 2018 I met Vicky Phelan when she was looking for a solicitor to help her fight her case. She went on to win that case and uncovered a shocking healthcare scandal that has affected so many women and families across Ireland. We also became friends. Vicky went on to fight one campaign after another for women's healthcare in Ireland, and all the time fighting for her own life, fighting for more time. This is a series of conversations where Vicky and I discuss what went wrong in CervicalCheck, how those fatal and life-changing mistakes happened, and look at what Vicky has achieved since she became an advocate for change. Hello again, I'm Cian O'Carroll and
I'm Vicky Phelan.
Welcome to In Conversation with Vicky Phelan. Today we are talking about the CervicalCheck Tribunal and looking at a couple of things. First of all, looking at recent revelations about how much is being spent on a tribunal that appears to be less than popular with its target audience, and then going on to look at how the tribunal came to be. Why is it there? What's it all about? And ultimately then looking at what it may, those people that it may suit, and also explaining all the various categories of people that are excluded from it and can't apply even if they wanted to. So, Vicky, kick us off with your reaction to revelations about the really extraordinary amounts of money that are being spent on this tribunal.
Yeah, so I woke up this morning to, I get notifications on my Twitter feed when there's anything related to CervicalCheck or the tribunal, which is useful while I'm over here. And again, I'm 5 hours behind, so it's useful in some respects because I can see the reaction to something, 5 hours later before I put up my own comment, which is useful at times. So there was an article in today's Examiner about the cost of the CervicalCheck Tribunal. So there were two figures that really jumped out at me. First, the overall cost that is, to the state that has been put into this tribunal. So it's about $2.5 million it's cost to get it to this stage. And the number of people who have submitted claims to the tribunal to date, which is a total sum of three people who have put in a claim or put in an application to the tribunal. And, we were expecting small numbers, to be quite honest, and we did warn Minister Donnelly that there would be very few people who would apply to the tribunal for the various reasons you're going to outline, because there are certain categories of people who are excluded from applying to the tribunal, which we laid out in very specific terms to the Minister at the time when we were in negotiations with him. So I'm not surprised, to be quite honest, that there are very little, so few applications to it, but I'm absolutely shocked at the cost that it has cost the state to set this up so far. I mean, $2.5 million will go a long way towards a redress scheme for women who maybe, only for the non-disclosure element of the CervicalCheck, for women, $2.5 million will go a long way, to set up a tribunal that has achieved nothing and is not fit for purpose for the people and the category of women and families that it's intended for. It astonishes me, to be quite honest, that that's not a sackable offence, really.
It's extraordinary that they would look at it as a bricks and mortar operation instead of trying to identify ways that they could address the needs of the women that they had harmed.
Exactly.
And to spend 1.6 million euros in doing up a building that you're renting for almost $500,000 a year.
Yeah.
Now in that $2.5 million, they've only included the rent for 1 year. Jeez. There's a lease on that building.
Yeah.
And I would be gobsmacked if that lease wasn't for 10 years.
Are you serious?
And we've seen this before with court buildings.
Oh,
well,
God.
maybe it's for less than that, but to spend that kind of money on a building, now maybe they'll find some use for it other than the CervicalCheck Tribunal. I'd hope so, but they're spending nearly €500,000 a year on rent. Then they've spent the 1.6 million to do it up. They've got a judge who has retired, now back on full salary since last November. They haven't even included the staff, the other staff.
Yeah.
Should they have to have staff? They've got 3 courtrooms they've created in this building. 3 courtrooms. And they've got an art allowance.
No,
What's that
I'd love to know how much that was, what percentage, because it just says a percent. Yeah, come on.
The building I work in has 26 or 28 courtrooms. What?
If they had spent money on comfortable chairs or cushions for the women who are going to this tribunal rather than art, I'd have a bit more respect for them.
In fairness now, we know. In fairness now to Stephen Donnelly, he has reassured your group time and time again that the most comfortable furnishing has been provided in this complex. So I won't hear a word said about the furnishings. I believe they are only gorgeous. But there's 160,000 euros or something spent on furnishings.
Which is crazy.
So you know have to assume they're padded.
I can tell you, that the women and families involved don't give a damn about what the building looks like. They want to go in, do their business and get out of there. Do you honestly think they care what a building looks like or whether there's art on the walls? They don't. I mean, I could barely tell you what the inside of the courtroom number 2 looks like. I have very vague recollections of what that room looks like, because you're in, at that stage, when you're at that stage of your court case and you're up giving evidence, you're so nervous that you really don't take much notice of your surroundings. You're just looking at the judge or the stenographer sitting in front of you. You're not really taking in anything else. So to spend that money on a bloody building is crazy. There's no need for it.
I'll tell you who'd be interested in reading this article as well, the judge in your case, because he spoke about it recently, that you met him at a conference that you were both speaking at.
Yes.
And at that there was some reference by you to how uncomfortable and hard the seating is in that courtroom, in most of the courtrooms. I mean, it's really uncomfortable, and there's no decent seating anywhere, whether you're a lawyer sitting there all day, or all week, or a witness coming through. But you had mentioned this, and he was making the point that he came back from that conference. It was about 2 years ago, was it? It was up in Port
it was 2 years ago. It was in Port
I joined you later that evening, and he has been trying to get the court service to improve the seating ever since. 2 years on, it still isn't done.
Yeah, no, it's shocking. But look,
so he can't get 200 euros worth of cushions put in. But when they want this sham tribunal, which isn't a tribunal at all, it's a full fight, vaguely camouflaged courtroom that they can hide away these cases in because the media aren't allowed in, they can spend 2.5 million and rising. It'll be 4 million by the end of next year, you can be sure.
Yeah, and wouldn't that money have been better spent, in setting up a proper redress scheme, or a proper, to deal with a lot of the cases where, women maybe don't have negligence to prove, and fast track those and let those women get their, settlement money for non-disclosure. That money would have covered quite a number of cases, I would imagine, instead of spending it on furniture. I don't know.
Well, the money would cover quite a few cases, and people perhaps forget or get, it's not people forget, but the wrong impression might be given, because the most serious harm, a lot of the initial cases were with the greatest of harm. Yes. And as a consequence, the level of damages was very, very high. And obviously your case was the first. 2.5 million euros was the figure of damages there. And that was an unheard of amount of damages for a fatal injuries, a cancer misdiagnosis case at that time. And it was followed by a number of other multi-million euro settlements. So people perhaps became accustomed to high levels of damages and think that that is not what normal damages for people, even who've had really awful life-changing injuries from cervical cancer, would expect to get.
Yeah, because I remember at the time of my court case, before we were, we were getting ready for the trial date, I remember asking you, what kind of settlement would I get out of it? And, at the time, I think most of the settlements were in the region of 700,000. Wasn't it, roughly, for cancer settlements, something like that?
Oh, absolutely.
Yeah,
absolutely.
And Cian,
that would be a very typical figure.
Yeah, and that's what we were. I mean, that's what I was expecting, and that's what I was expecting.
That wasn't a figure of damages for for a cancer misdiagnosis case. That was a figure of damages that you would expect for a fatal injury cancer misdiagnosis case.
Right. Okay.
So we've discussed about this before, and it was an unacceptably low level of compensation, but we managed to improve that very substantially in your case, and I think that had a knock-on effect that led to very good outcomes in money terms in other cases. But to come back to the tribunal, leave aside the issue of damages though. I mean, really, it's like, what is it for? What's it about? And why see it as being a bricks and mortar operation where you need to put in place this? I'd love to see what it looks like, because I spend a lot of time in courtrooms and they're not great.
No.
Certainly the ones in the main civil courts complex in Ireland, which is the four courts. It's got its charm and I enjoy working there, but as rooms for people to sit all day in and people with a lot of injuries, they're really not very suitable at all. So what's going on here? Why would they spend all this money? So I thought we'd look back and see how it all came about. And why is there a tribunal anyway when courts seem to be dealing with cases like yours within 12 weeks? And so do you remember what started all this?
Yes, absolutely. I think everybody probably remembers it because he gets reminded of it so often. The Taoiseach of the day at the time, Leo Varadkar, was on the 6-1 News following my case, I suppose, and the fallout from that. And there were now a number of cases. It was quite obvious that there were going to be more women coming forward with cases. I think Emma Vic Fahuna's case was had been speaking on Radio 1, and people were horrified that this single mother of 5 was now also going to have to go down the same road as I did. So there was a huge uproar both from the public and in the media about the fact that, this cannot continue. What is the government going to do for these women? So the Taoiseach was asked on the 6-1 News by Cian O'Carroll, who was a fantastic journalist and who, as we know, died of cancer last year herself. But Cian really had him on the ropes with questions. She had herself well rehearsed on what was happening and how this was going to go. And she basically forced the Taoiseach, I think, into a situation where he had to say that the government would stand with the women and sue the labs afterwards. So we have the Taoiseach of the day on the 6-1 News, saying that was going to happen. And of course, here we are, how many years later, and that has not happened in any situation.
No. And he also said about mediation, because I think there was a general sense that mediation is a nice fluffy word and everybody hears mediation and thinks, oh, that sounds like a lovely alternative to the courts. Of course, the reality is that mediation, while it does work in many situations, it works at the very end of a court, of preparation for a court. So you go into mediation maybe the week before the trial, and the trial is hanging over like the sword of Damocles, hanging over both parties, but perhaps more the defendant. In any event, Cian O'Carroll did an amazing job on that interview. And I looked for it on the RTE website. We might be able to get a clip of it to pop it in here. It's just...
It would be great,
seeing she was such a talent, and to get a Taoiseach in that position, it really does seem to require tremendous skill because it so rarely happens.
Yes, yeah.
But he made those promises, he made those assurances, and a lot of people bought into those assurances. And then he let everyone down.
Yes,
repeatedly.
He did. Oh yes, repeatedly.
So the promise was that the state would stand by women in mediations or in litigation, that they would stand against the laboratories, and that they would try to settle cases with the women and then pursue the laboratories for the cost of that, because the state had in contractual indemnities and legal indemnities which allowed it to pursue those commercial entities for the cost of the damage that they caused. This was the exact argument that we were making at the time, which is, how do you deal with all these cases? You deal with them by having a situation where we only sue the HSE. The HSE then settles with us and goes after those laboratories, international entities as they were, for the cost of all of that, both the compensation and the legal costs. But somebody didn't want to do that.
No, they certainly didn't.
Somebody powerful didn't want to do that. You never found out who or where they were, did you?
No, we didn't. We never found out. I would assume that a lot of that came from the Department of Health. Now, I could be completely wrong. And the State Claims Agency. I think the State Claims Agency obviously told Mr. Varadkar that that was not going to happen. I would imagine, at the end of the day, the State Claims Agency are there to protect the interests of the state. So my assumption would be that it was probably the State Claims Agency and probably the Department of Health, the CMO, together probably maybe had a bit of a chat with Leo to tell him that wasn't going to happen. But we were never told who it was. But he quickly backed down from it, as you remember at the time.
And yet the High Court and the Supreme Court subsequently concluded that that is effectively what could have been done. They didn't say that it should have been done because that isn't their business.
Yes.
But they did say that can be done, and there is no reason why you cannot have a situation where the state, where the HSE, who is the sole primary, or has primary responsibility for the running of the service and primary liability for the errors that occurred, to deal with those and then mop up with the laboratories. And even today, they still won't do that. They say very vaguely to me that they have some issue where they can't be sure they'll be able to recover from the laboratories. They can't be sure. They've never tried. They are recovering. Okay. The laboratories are paying for all these cases. Remember that. And I mean, it's important for people to know, following this, that the laboratories are paying for the consequence of all this. All Leo was saying, and I think he should have done, was that the state could bridge the gap and allow people to have their cases settled now and quickly. And then the state would do the heavy lifting with the antagonistic party, the laboratory. But anyway, that didn't happen. And as you say, he started retreating from that pretty quickly.
Yes, he did.
You then got involved after Ruth Morrissey called him out in July. So Ruth ended up in the High Court, very, very sick. People will remember her clearly looking like a person who was going through chemotherapy. She had no hair. She asked for her anonymity to be lifted so that people could see her at the start of her trial.
So I met Ruth not long after she contacted you, actually, to start her proceedings, because she lives literally 1 mile. Her house is literally a mile away from my house. So like, we're living in the same parish. Our children go to different schools, but same parish. So we met a number of occasions after she had started her proceedings with you. And I remember meeting her just before the trial started, and I'm so angry, Cian, because she was so sick, she was so ill, she was in the middle of treatment, and she was having to go up to give evidence. And it just absolutely enraged me, to be quite honest, that this was happening again. And not only was it happening again, but it was happening to a woman who was very, very ill. Ruth was far sicker than I was when I had to give evidence, and it really enraged me, particularly when Leo Varadkar made these assurances that this wouldn't happen again. So I just lost the plot, I suppose, and I just contacted the Taoiseach's private secretary. Had contacted me, and I had his number from an appearance I had done on Primetime a couple of weeks before that. So I had his number, so I contacted him and asked him for a meeting with the Taoiseach, not knowing that this is probably not something that is done, but I just thought, no, I'm just not accepting this. So I asked for a private meeting with the Taoiseach, and I told him what dates I'd be up for treatment, because I wasn't going to go up for an extra day for anything else, and I'll do it on the same day I'm up for treatment. And I met with the Taoiseach in August. I think it was the very beginning of August. I think Ruth's case was probably in day 15 or 16 at that stage. Possibly it was in July it started, wasn't it?
Well, it started in July, but then it stopped for the summer break, and then it came back at Christmas, and then it was on through the following year, when really the most of it was being dealt with. So it was just a couple of days there before the summer break the court breaks for August and September.
Right.
So it was during that long vacation. You had your meeting with Leo.
Yes.
I can remember I was abroad on holidays with my family, and it was all kicking off.
Yeah, so I met with the Taoiseach that day, and I had a good, I'd say I was in there for about 2 hours, good meeting with him and his people. And, at the end of it, he assured me that he would look into setting up, at that stage he'd had advice obviously from numerous sources, and he started talking about a tribunal. So that's when the first mention of a tribunal kind of came into play at that point, and he told me that he had been appointed Justice Charles Meenan to do a scoping exercise into what format a tribunal would take. So that was what came out of that meeting in August.
And his PR around that time, by the way, when I say I was away on holidays, the court had adjourned for the summer. I hadn't run away and abandoned the trial. The public relations handling of all this by Leo Varadkar, he was really pushing this idea that this was that it was possible to create some kind of non-adversarial forum, and that he was working towards that. And my view was that the use of the word tribunal has been relied on heavily to fool people into thinking that what they've actually created is something like the Hepatitis C Tribunal,
yes,
or the Residential Institutions Redress Board, that it's that type of tribunal where people go to have compensation assessed, as opposed to a place where you would go where there's a full fight and brawl over every part of the case, liability, causation, damages, which is what happens in a court.
Yes.
It's exactly what happens in this tribunal. Now we'll come back to that, but he was already talking about it as a tribunal, and as you say, he asked Mr. Justice Charles Meenan to look at what the options were around this, and Judge Meenan then spoke to various parties, spoke to you, spoke to me, and I'm not sure what aspects of it you spoke to him about. You probably wouldn't have been dealing with the
legalities. No,
we
were dealing with, the reason he spoke with myself and Stephen Teep and Lorraine Walsh, so we were the patient advocates with the 221 Plus group, because at that stage we were in the throes of establishing the 221 Plus group that was launched on the 15th of October, I think. So we met Charles Meenan, I think maybe the week before. So we were just kind of, but obviously at that stage we'd had a lot of women. We had set up a Facebook page where people were contacting us. So we'd had a lot of contact from women and families, and we got feedback from them on what way they would like, this to be, what type of format they would like to see. So we got feedback from our members, which we presented when we sat down with Justice Meenan. And really one of the main things that we were trying to get across to Justice Meenan at the time was the emotional impact and the consequences, the side effects of this disease, because I don't think he understood what he was dealing with. We spoke to him about, what the difference was between somebody who went from, kind of pre cancer to, fully invasive cancer, what the difference is in the type of side effects and what that woman would live with, to somebody like me, to somebody like Lorraine who couldn't have a child as a result of it, to somebody like Stephen who's lost a wife. So we wanted to show him the personal, the human side of the cost of this disease, and what that harm has done to us. And I think the fact that three of us had three separate stories was probably good. And he was quite taken aback. I do remember that meeting. He was quite taken aback at the level of harm that was caused by, a misread. Because I often think that, if you don't explain this to people, what that change in reading a slide means to somebody, they don't really understand what impact it has had on your life. So that was what we were really sitting there with him for that day, was to make sure that he understood what this meant for somebody who was taking a case.
Well, ultimately, I think he had an impossible task. He was presumably told that the state is not going to do what Leo Varadkar said it would do. So your starting point here, Judge Meenan, is that we are never taking over these cases and going to run them and then mop up with the laboratories. So you've got to come up with a system that looks like it's non-adversarial, and yet provides for a laboratory or laboratories in each case who are going to be allowed to fight the case tooth and nail. So, I mean, those are two things that can never be reconciled.
No.
And now, I certainly, when I spoke with them, it was obvious that there was no magic bullet that was going to solve this problem. But I did say that, you know, most of our clients at that stage either had legal proceedings commenced in the High Court or were rapidly heading in that direction. And if you're going to attract people away from that and into a tribunal, which even at that stage we never thought would take nearly 3 years to be commenced. But I said it's got to be attractive. And the only thing that I could see that would make it super attractive to claimants would be allowing them, as you do in the hepatitis C tribunal, to come back if their condition deteriorates. And this becomes very relevant later, but you know, I said that if this tribunal were established as a full fight forum, as it would have to be, but still allow people to come back if they've proved their case, that would allow them then to go to the tribunal and seek compensation at this stage that would allow them to put in place the care they needed to make up for the loss of income that they have, to provide for their kids in the way they would have if they hadn't been injured, and still not have to write away the potential for further huge losses were they to get bad news that their cancer was back in 2 years' time, for example. And that's the recurrence issue. Now, that didn't feature in his report, and it certainly hasn't featured in the makeup of this tribunal.
No, and it is one point, Cian, that we argued absolutely tooth and nail for in our negotiations with the minister. That, you know, there were 2 points that we were not going to budge on, and one was the recurrence piece that you just explained, and the other piece was the statute of limitations, which was going to be a huge issue for a number of people. You know, how can you expect somebody to take a case to the tribunal and not take proceedings to the High Court when the statute of limitation is 2 years from the day that harm was caused? And, you know, through no fault of their own, these women or their families, you know, were waiting for this tribunal to be established, should not have been penalised if the statute of limitations had run out. You know what I mean? Because the tribunal was not ready in time for them. So that was a huge issue for us. Yeah.
Even if it was only one person who believed the garbage they were coming out with about the tribunal is coming, and it's going to be great. You know,
exactly.
Who does that sound like? It's going to be great.
Yeah.
And if one person believed that and found themselves statute barred, they should have put in a provision to allow for that.
Absolutely.
They came back with raw mate about how, you couldn't do that because of the Constitution. Even though the Tribunal Act itself amends the statute of limitations. It just doesn't amend it to favour the poor misfortunate person who's been harmed and who waited around for the tribunal. So that statute of limitations argument, none of us know how many people are affected by it. But
we did a survey of our members. We did a survey of our members to try and find out how many people might have been in that category. You know, so what we were trying to find out was which of our members in the 221 plus group, because it was really affecting the 221 plus group, because the date would have been from the 26th of April or the 25th of April, whenever or from the date of their meeting, which happened kind of in early May. So we kind of reckoned that it was May 2018 would have been the date, you know, the point at which the statute of limitations would have kicked in, because most of those meetings would have happened in May. So whenever they had that meeting with their consultant to be told about the harm, that was when the statute of limitations kicked in. So it really only affects anybody in the 221 plus group, because the RCOG group came later, almost a year later, so that they're not affected by this issue. So we contacted everybody within the 221 plus group and tried to find out how many people might be in that situation. So what we were asking for is, how many of you have not issued proceedings, you know, because and that's really what we were looking for. And we got it was very small, because most people would have issued proceedings at that point. I think it was maybe between 6 and 10, but it was still 6 to 10 people, you know. I mean, that's not an insignificant amount. And that's what the point we made. That is the point we made to the minister, to Minister Donnelly. It's a very small number of people that we're talking about here. You know, please, you know, can you not meet this demand? You know, because it needs to meet the needs of our people. and there are a number of people who are affected by this, but no, there was absolutely no, they didn't even meet halfway,
and yet, And it was he and his predecessor and the Taoiseach who had repeatedly told people that there was a tribunal coming and it was going to be great.
Exactly.
And so it is absolutely the case that people waited for that and had an expectation.
Yes.
And for them to lose out as a result of that is appalling, and that they wouldn't make any effort to address that in the legislation when it is not a difficult thing to do. There were two ways they could have done it. First of all, there's already legislation which is enacted and awaiting. You have an act which may be debated, then passed by the Houses of the Oireachtas and ultimately signed by the President, but there are sections within it which haven't become operative yet. And that is the case with the extension of the statute of limitations to 3 years for any action relating to medical negligence. So that's one option, but it would have affected other people outside of the cervical check debacle, as you've informed me it should be called. And the other option is that you simply put it into the CervicalCheck Tribunal Act, that anybody who falls within the very limited categories of people who are entitled to apply to this tribunal have 6 months from the date of the tribunal opening its doors, regardless of the statute of limitations.
Yeah.
To bring an application. And the only reason they didn't want to do that was because, again, they were afraid that their good buddies in the labs wouldn't like it. Because the only people who weren't going to like that were the labs.
Yes, exactly. And that's the argument that we kept getting back, that it was the lab, what if the lab, and it was kind of, what annoyed me was it was even the way they phrased it. Well, what if the labs don't, contest this? Again, it was
like
what
it?
Exactly, And I remember saying at one point, sorry.
Well, the dread fear there was that the labs would then say, well, you've allowed in a case into the tribunal. Somebody's after having their horrible injury assessed. Maybe there's 150,000 euros of damages that's assessed. And the lab says, no, we're not standing over our indemnity because technically speaking, that case was statute barred. And in the courts of Ireland, we wouldn't have had to pay up on that. And you have to carry it yourselves. And big deal, so what if the state had to carry that 150,000 euros or whatever for the harm they caused to somebody when they're happy to spend 2.5 million on 3 courtrooms that'll never be used up in Smithfield.
Exactly, and that was the point I made at one of our meetings, actually. I got quite agitated over that. And I did make that point. I said, you're talking about a very small number of people here. You just have to suck it up. Surely, it's your fault that this has been delayed. Could you not just give us this olive branch, as I saw it, and make that, exception for this very small group of people? And absolutely no, they just would not budge. It was so infuriating, to be quite honest.
Yeah. It seemed to be, I saw the correspondence that was going over and back between you, and it really did look like there was somebody in there or people in there, and they were saying, we're not going to be told what to do by these people. We're going to dictate to them what this tribunal is going to look like, who's going to be allowed into it, and they either like it or lump it, and good luck to them. But I can't understand, to spend this amount of money on something that they knew was not even close to being of use to all of you women and the families attached.
Yeah. No, that's why we pulled out. We just, we pulled out of negotiations, and we sent a statement out saying that we could not support the tribunal, and that we were not supporting it, and that we would be advising our members to get legal advice, because at the end of the day, it's not up to us to tell our members what to do. But at the same time, we said we had to give them all of the facts, and the facts were that, this tribunal is not fit for purpose, and we would not support it. We couldn't stand over it.
And it's not even, we're going to continue this discussion into a second episode, because I think we want to look at the nitty gritty of who isn't allowed to apply to the tribunal and why they're not allowed to apply to the tribunal, and really all the various reasons why the tribunal is so useless for what is needed here. This is no fault of the people who are going to be working in it, or no fault of the judges. they're just appointed to do a task, but people that I spoke to really wanted the tribunal to be an option.
Yes.
It's not that
no.
It's not like it'll probably be portrayed now that these are, this bunch of ingrates who want to just go along to the High Court and have a trial. Nobody wants a trial.
No, nobody wants that. Not in a million years. No. Anyone who's been there.
And nobody wants to have to sue a laboratory either, because they know that they're, a nasty bunch in litigation so far. They have not behaved very well. But the HSE has behaved appallingly as well, literally operating hand in glove with these laboratories in so many cases.
Yeah.
And we've seen it up close, and it's not very nice. And the most they'll ever do is stand back and go, "Oh, we're neutral in this. We're neutral." They're not even neutral. If they were neutral, that'd be something. So now we're at a situation where, Judge Meenan produced his report back in October of 2018, which is over 2.5 years ago. So he did his job. He produced, in fairness to the man, I mean, what else could he have done but suggest some form of litigation forum that was off to one side? You can call it a tribunal, you can call it a court, but it is a court.
Yes.
It's the High Court. And then nothing happened. What was that about? This is long before COVID-19.
Initially, the delay initially was because it had to be drawn up. So legislation had to be drawn up to enact CervicalCheck Tribunal. And apparently what we were told was there's only 1 or 2 people. I think there's definitely only, at the most 2 people within the department who do this type of work. So there was a backlog, and that's what happened. So the first delay was they didn't have anybody to draft the legislation that was required to bring it forward to the Dáil so that it could be voted on. So that's what the original delay was. But that took nearly 12 months, I think. So that was October 18. Yeah, that took, I think, up to maybe October 2019. It was just before December, I think it was enacted. Wasn't it December 2019? Just about.
I can't remember.
I'm sure it was.
I can't remember that momentous occasion.
I remember it being around Christmas, kind of December 2019, when the legislation was drawn up, to... So
they had no drafters in the Department of wherever, Justice or whatever, to do that.
Yeah, exactly.
So you could hire a few of those with 2.5 million.
Exactly. And we actually made that the point at the time, can you not pay somebody to, an extra, to give to somebody else to, bring somebody in to draw up this legislation, because, and we we've lots of correspondence going over and back with the department, with the minister, about the fact that, the statute of limitations was starting, we made that point that there will be a 2-year limit. You need to kind of move on this here in order to get it in place so that people can, apply to it. But, we weren't listened to. And then, sure, COVID came along then in March 2020. And, they had maybe a window of 2 or 3 months where something could have happened between January and March, and nothing happened. And then COVID came, and that
and
really
the statute ran out then for really anyone in 221.
In May 2021.
With the exception, in May 20... No, in May 2020.
May 2020, sorry, May 2020,
In May 2020, and the tribunal still wasn't set up. You couldn't bring an application, and you couldn't do that until, what, January, was it, or March, or December last?
December last, yeah.
December. So by the time they set it up and allowed applications in, the statute was expired by about 6 months.
6 months, yeah.
Right. And so all those people had to have launched High Court proceedings.
And that's what we advised.
If they were going to have any cause of action. And now they're given out because people aren't leaving the High Court proceedings and coming into their beautifully furnished, art-bedecked, COVID-friendly halls in Smithfield, where they've spent their 2.5 million.
Yeah, exactly. And that was another issue that came up. What about people who have issued legal proceedings and have already started, solicitors have, started getting costs and getting experts, and all of these costs are accruing. What about people that are in that situation? Are you going to cover their costs if they move to the tribunal? Again, we couldn't get an answer on that for quite a long time. So, it was so frustrating, to be quite honest, dealing with them, because, how could we advise any of our... They did, eventually.
They did deal with the transfer arrangement because they realised that the only way they were going to get any applications was if they had to transfer in, unless they were going to attract in people who were identified through the RCOG review, who had not been part of the 221 group. And we don't know how many that is, but it's about 80 or 90, it seems. It's not clear.
Something like that.
A distinct number was never given for that. So there is a small cohort of people within that who wouldn't have issued proceedings and who can still make an application to the tribunal within the statute period. Yeah. And perhaps the 3 applications they've received so far, there will be more than 3, but they're 5 months in. Yeah, 5 months, exactly. 5 months into a 9-month open door period. So the tribunal is only open for 9 months. Five of those months have elapsed, and they've got 3 applications. And I suppose there could be a late rush, but clearly it's not seen as being attractive to clients. I mean, we've written to all of our clients about the tribunal, and I'll frankly say that I have said that I don't see the advantages in general, but I do see advantages in very specific situations. But people just, they read the correspondence that went on between 221 Plus and the minister, because you sent that to them. You sent them. We did. You basically polled your members to find out how they wanted you to deal with this at the final twist, and you sent all that correspondence, and people were enraged by it. They were absolutely enraged. Yeah, because the tone of the correspondence was so dismissive of us. It really was. They just there was nothing taken into account. There was no meeting us halfway, nothing, and that's why we felt it important that all of our members saw exactly what we were having to deal with in this negotiation, And people had said to me as well that they had seen how effective the High Court had been. It protected people's anonymity where they wanted to protect it. It dealt with cases quickly where they needed to be dealt with quickly. It had experienced difficulties and delays through the period of the last year, and before there were delays as well. There had been delays getting cytology released. We had to go to the courts over that. I would be surprised if the laboratories would turn over a new leaf within the tribunal and suddenly start to progress cases quickly, when they had been not doing that within the court process. The legal expense for everybody involved would be roughly the same between the two. Yeah, of course. But it does have to be said that it sounds like the furnishings, which the minister did repeatedly refer to, it did sound like they were an awful lot better in the tribunal. So if you wanted a nice seat to sit on, it was definitely the place to go. I do hope to see it sometime. Yes, so would I. I'd actually be very curious. Although I'm sure I wouldn't get an invitation to go, but there we go, The place they put on out in Sandyford, I think it was, for the Residential Institutions Redress Board, for all the poor misfortunate adults who had been children and put away into these dreadful torture schools, was appalling. Really? Okay. It was a really awful, grim, windowless place, with a coffee machine. One of those things you put a cartridge into the coffee machine and you'd get. But this sounds like it's so much better. Certainly the place out in Sandyford didn't have all that fancy furniture put into it. So, but that brings us, I think, to the end of this part of the discussion, and then we might be a little bit more particular and go through the various points when we look at the pros and cons of the tribunal when we next talk, when I'm next in conversation with Vicky Phelan. Thank you, Cian. Looking forward to it. Thank you very much. Hi. Vicky and I hope that you've enjoyed that episode and you're finding the series informative. If there's anything else that you'd like us to discuss or touch upon, please mention it in a comment below. And to be informed of future episodes, hit the subscribe button.